For our final panel. Almost every business has intellectual property, and it's often one of the most valuable assets. Protecting those assets is important. For our final presentation of the series, we're going to reach out across 2 time zones for this panel. Erica Van Loon is a partner in our Los Angeles office and leads our intellectual property litigation practice. Eric Sidler is an IP litigation partner in our Kansas City office with his own wealth of experience. So I will turn it over to Erica and Eric.
Thank you so much, Jean Paul. Hello, everybody. I hope you are still awake. I am speaking with you today from Los Angeles, California. I am a partner and the head of the IP litigation practice team here at Lathrop. This has been my area since I started practicing law, and I've had the good fortune of representing many high-profile clients in really interesting trademark, copyright, and patent cases, including Mattel, Nike, Conan O'Brien, just to name a few. A little about me: I have gotten very good at doing my job from my bedroom. I have taken several Zoom depositions, done Zoom mediations. The only thing I have not done yet is a Zoom trial, and I'm hoping I don't have to do that, but the way things are going in California, who knows? So with that, we have a lot of material to cover today. This has been a really active term in the U.S. Supreme Court for IP decisions. But before I get to that, of course, I want to introduce my colleague, Eric Sidler. Eric, go ahead and tell us a little bit about yourself.
Thank you, Erica. Hi, everyone. Great to be with you. Thank you for sticking around with us this afternoon. I'm an IP litigator based in our Kansas City office, as Erica mentioned. And my practice runs the gamut of IP litigation, from patent, copyright, trademark, trade secret, false advertising, and domain name disputes, to administrative proceedings in the PTAB and the TTAB, as well as related counseling. I'm the parent of 2 toddlers, and so I've been transitioning to that, and it's been interesting, to say the least. I have enjoyed the occasional dance lesson for my daughter, who's really into ballet right now. So that's my COVID life. Thank you.
Great, thanks, Eric. So as I was mentioning, there have been several very interesting IP decisions coming out of the U.S. Supreme Court this year. And we'll start first by talking about some of the trademark decisions. The first case I'm going to tell you about was filed by the U.S. Patent and Trademark Office against Booking.com. Very interesting decision. This was an 8-1 decision authored by Justice Ruth Bader Ginsburg, with Sotomayor concurring and Breyer dissenting. And this case concerned whether or not you can have trademark protection when you have a term coupled with a top-level domain name, such as a .com. So in this case, the trademark at issue was Booking.com. The Trademark Office tried to argue that there was a per se rule against being allowed to register a mark that, in the USPTO's opinion, was a generic term coupled with a domain name. The U.S. Supreme Court soundly rejected that per se argument. This case established that marks that include a .com can in fact be registrable and protectable via trademark. And one of the things that the Supreme Court really looked at was a consumer survey performed in the case that showed that consumers perceived the Booking.com mark as referring to a specific brand rather than a category of travel accommodation services. So the Supreme Court found that survey very persuasive, and again held that Booking.com was viable and could be protected via trademark. So what's the takeaway from this case? Well, there was sort of a trend away from registering your .coms as a trademark, but the court has now said, no, you can register these. So I think probably many of you have a .com associated with your trademarks. So you should take a look at how you're using your .coms. If you're using them in a trademark sense, you should really strongly consider going ahead and registering your trademark, whatever your brand name is, .com, as its own trademark if you haven't already done so, for added trademark protection. And now I think we're going to have a polling question. Okay, so as many of you know, Justice Clarence Thomas is not well known for asking a lot of questions during oral argument, but I wanted to see if you guys could answer this. How many questions do you think Justice Thomas asked in the Booking.com oral argument? Please submit your response now. And we should get the results in just a few moments. Wow, you guys are very smart. 37% of you chose 4 questions, and that is the correct answer. Justice Thomas did ask 4 questions during the Booking.com oral argument, which incidentally was the first oral argument ever to be live streamed by the U.S. Supreme Court. So next, I'm going to turn it to Eric to talk a little bit about another really important trademark decision this year.
Thanks, Erica. Next slide, please. Right, so the second decision in the trademark world, notable is Romeg Fasteners versus Fossil, which came down earlier this year. And this involved Romeg Fasteners, which is a maker of magnetic snaps and other closures, and Fossil, which is a maker of watches and fashion accessories, as you may well know. Fossil entered an agreement with Romeg to use Romeg's fasteners on Fossil's products. There were alleged counterfeits of those products created by a Chinese manufacturer. Romeg sued Fossil for trademark infringement. And a jury found that Fossil had acted in quote unquote callous disregard of Romeg's rights, but rejected the notion that the infringement had been willful. And on that basis, the district court denied Romeg's claim for infringers' profits, which is one form of monetary remedy available under the Lanham Act, relying on Second Circuit precedent that required finding of willfulness as a precondition for that remedy. There has been a circuit split on this issue for some time until the Romeg Fasteners decision, in which the Supreme Court, in a unanimous decision authored by Justice Gorsuch, rejected that notion that willfulness is a precondition for disgorgement of infringers' profits. The court held on to the relevance of this in assessing whether profits should be awarded, but said we're not going to require this as a per se rule. Why is this important? For trademark owners, they'll now have an easier time obtaining a monetary remedy in the absence of actual damages, which can be difficult to prove. And it provides a strong justification both for pursuing litigation and maintaining it, and increases their negotiating leverage. On the other side, for accused infringers, they'll now have much more at stake than just the prospect of an injunction. They'll have to really look closely at their level of knowledge of the asserted mark that's being asserted against them by the plaintiff. Even if they didn't act willfully, they'll have to look really closely at when they became aware of it, should they have become aware of it. And this increases the importance of good trademark clearance searches. Parties may now be subject to disgorgement of profits even without willfulness. So that's the Romeg decision.
Thank you, Eric. Yes, certainly out here in the Ninth Circuit, this is a big game changer. It used to be that you had to show willfulness in order to be able to disgorge a defendant's lost profits. So as Eric mentioned, this is really going to change the way you handle when you receive a cease and desist, if you're on the receiving end of that, and trying to settle cases out early when you don't have to prove willfulness in order to be able to disgorge profits. Okay, let's turn to the next slide. So this was an interesting case. This was Lucky Brand v. Marcel Fashion Group. These are two brands that have been bickering for years over the marks Lucky and Get Lucky. This was a unanimous opinion written by Justice Sotomayor. And it really isn't a trademark decision. What happened in this case was there had been a series of lawsuits between the parties, but in one of these suits in 2005, a Lucky brand sued Marcel for infringing its marks. And in that case, Lucky brand raised certain defenses initially in the case, but it did not ultimately maintain those defenses throughout the course of the litigation. Flash forward, ultimately there was a jury verdict in favor of Marcel and an injunction entered against Lucky brand. Then a couple years later, a third lawsuit was filed between the parties, and Lucky brand tried to assert some of the defenses that it had raised in the prior lawsuit, but not maintained throughout the course of the litigation. Marcel tried to argue that the defense of, well, they tried to argue that there was defense preclusion, and that Lucky could not assert the defenses it had earlier raised in the earlier litigation. So this went up to the Supreme Court, and the Supreme Court rejected Marcel's notion that there is some, per se defense preclusion. Not surprisingly, the court found that claim preclusion, issue preclusion is pretty fact specific. And in this case, the court looked at the facts at issue and found that what was coming up in the third lawsuit involved different marks and different conduct at different times, and therefore Lucky brand could go ahead and assert those defenses again in the later filed suit. And the Supreme Court specifically noted there is no, per se defense preclusion rule, not surprisingly. So bottom line here is that, as always, issue and claim preclusion and defense preclusion issues are pretty fact specific and hard to come by if you're trying to make a preclusion claim. Now we're going to turn to some copyright decisions that were that came out of the U.S. Supreme Court this last term. If you could advance the slides, thank you. One more. Great. So the next case I want to tell you about was Allen v. Cooper. So in this case, a videographer was hired to document a shipwreck recovery off of North Carolina and sued the state for copyright infringement. North Carolina came back and said, you know what, we have 11th Amendment state sovereign immunity. You cannot sue us for copyright infringement. Interestingly, the plaintiff came back and tried to use a statute called the Copyright Remedy Clarification Act to argue that no, North Carolina, you can be sued for copyright infringement and 11th Amendment immunity doesn't apply here. So this went up to the US Supreme Court, and the US Supreme Court actually struck down the Copyright Remedy Clarification Act that had been enacted by Congress as being unconstitutional, and said that Congress could not abrogate state sovereign immunity. The court looked at a couple of different arguments raised in this case. It shot down the Copyright Clarification Act. It looked at and rejected the argument that Congress was allowed to abrogate immunity pursuant to Section 5 of the 14th Amendment. And so bottom line, states appear to have immunity from copyright infringement claims. This has always been the case in the Ninth Circuit, but now, the Supreme Court is making that clear and has struck down the Copyright Remedy Clarification Act. Okay, next slide. So the last copyright case I wanted to tell you about is Georgia v. publicresources.org. And this was an interesting case where actually the state of Georgia tried to sue a nonprofit that had posted some official codes from the state of Georgia on its site, including some annotations to those codes. And so Georgia tried to sue the site for copyright infringement. And the Supreme Court held in a very interesting decision that no, actually the state was not eligible for copyright protection for codes that it enacted and wrote in its official capacity. So Georgia does not have, and states in general do not have copyright protection for laws that they enact. So that means that any site such as publicresource.org or any other site can freely republish the codes without being liable for copyright infringement. All right, I hope everybody's still awake. I think Eric's going to ask a few polling questions next.
Thank you, Erica. Yes, we do have some polling questions for you, if we could put those on the screen. And this is actually a collection of 3 questions, all have the same choices, and they differ slightly. The question is basically, how do you believe that the number of new trademark, copyright, and patent litigations filed in federal district court so far this year, 2020, compares with the same time period last year, January through July? Do you believe it's significantly increased, slightly increased, about the same, slight decrease, or significant decrease? We'll give you just a few moments to submit your answers. All right, let's see the results, if we could. Okay, for trademark litigation, majority felt, or plurality felt that there's been a slight increase in filings. Copyright, the same. And as far as patent, most of us felt it's been about the same. As for trademark and copyright, there's actually been a significant decrease in new cases filed. Trademark is down about 22% so far this year as compared to 2019 through July. As for copyright, it's even more, it's almost 50%, just under 50%, likely due to COVID. It's interesting though that patent litigation has actually increased slightly as compared to 2019. It's up about 11% through July. So right now we're gonna move to patent litigation. If we could turn to the next slide. Specifically, litigation before the Patent Trial and Appeal Board, or PTAB, which is the administrative body under the auspices of the United States Patent and Trademark Office that decides various post-grant review proceedings involving issued patents, reviewing the patentability of patent claims after they've been issued. And one particularly notable issue that's arisen in the last several months, or come to the fore rather, of non-merits-based denial of institution of these sorts of proceedings, the most common being inter partes review, or IPR. The NHK Spring decision of the PTAB, which issued back in 2018 and has been designated precedential, is kind of the most notable of these decisions. It's kind of spurred this, this trend of just what's called discretionary denial, or non-merits-based denial. And the notion is that we're going to deny review not based on the merits of the petition, but rather based on the existence of a parallel infringement lawsuit involving the same patent and same parties in federal district court, particularly where that infringement lawsuit is further along such that the trial date is set to occur before the board's deadline to issue its final decision in the IPR. In the NHK decision, the board concluded that it would be an inefficient use of its resources and therefore denied review based on the existence of a parallel infringement lawsuit that was set to go to trial about 6 months before the board was due to issue its final decision, and then involved similar issues, the same patent, the same parties. And several PTAB panels have relied on this decision to deny institution on similar grounds. And if we could turn to the next slide. So what's the effect of this? Well, one effect might be an increase in, an acceleration in the decrease in institution rates. You'll see from this chart, which is taken from the USPTO through June of this year, there's been a steady decline in the rate of institution in these post-grant review proceedings, which include IPRs before the PTAB. And that appears to have accelerated slightly in the last fiscal year 19 through the present. And one reason may be that these NHK non-merits-based denials based on parallel litigation. We could turn to the next slide. I want to go through a couple recent PTAB proceedings that applied NHK and provide some insight into how the board is applying this. First is the Apple decision. If we could go back to the previous slide. The Apple v. Fintiv proceeding, which was another IPR, where Apple petitioned for review of a patent owned by Fintiv. The board articulated 6 factors that it would apply in determining whether it's appropriate to deny review based on a parallel infringement lawsuit. And it gleaned these from the NHK decision in 2018 and subsequent decisions applying that. And in doing so, it denied institution, and it relied primarily on the fact that, as in the NHK decision, the trial court was set to occur about 2 months before the board's deadline to issue its final decision. The district court had already construed the claims that were at issue in the IPR, issued a Markman order that was very detailed and robust. And there were similar invalidity arguments, similar prior art that were asserted in both proceedings. The board, interestingly, also looked to the merits of the petition, which is interesting, given that the notion is, you're looking beyond the merits in denying based on NHK, but it did recognize that the merits of the petition is a quote-unquote other circumstance that could justify this sort of discretionary denial, and it saw weaknesses in Apple's petition, and for that reason as well denied review. You turn to the next slide. Contrast that with another IPR involving Sand Revolution and Continental Intermodal Group. The petitioner here, Sand Revolution, petitioned for review, inter partes review of Continental's patent relating to fracking systems. And the board originally denied institution, relying on NHK, pointing to the existence of a parallel infringement lawsuit in the Western District of Texas for Judge Albright that was scheduled to go to trial several months before the IPR would finally be decided, and concluded that the facts were very similar to NHK. Well, shortly after that, the petitioner, Sand Revolution, requested rehearing of the decision, and the Apple decision was designated precedential and came out. That prompted the board and Sand Revolution to say, okay, we want you to address the factors that the Apple decision articulated. We're going to supplemental briefing, and not just that, but we'll allow more evidence to be allowed in. And based on this new evidence of record, the board reversed itself and granted rehearing and instituted review. And the most important evidence that was submitted was, number one, there had been several COVID-related extensions of the district court schedule from the date of the initial decision to the reversal of it, that basically caused the board to say, well, we don't know when the trial date is going to happen because of the pandemic. So the uncertainty of this is something that will lead us to not deny. And even more importantly, I think, was the fact that the petitioner submitted a stipulation saying that it would not pursue any invalidity arguments in the district court that it was pursuing in the IPR if review was instituted. And this caused the board to conclude that there wasn't really a danger of overlapping of issues. So next slide, please. So how do you reconcile these? Ultimately, the petitioner stipulation was very powerful to the board. And so to the petitioner can submit something like that, I think that really is important for tipping the scales away from discretionary denial toward institution. As well, you have to look at the schedule, both on the patent owner side and the petitioner side. Patent owners will want to avoid schedule extensions in the district court to the extent possible. Petitioners will want to, file their petition as early as possible to see if they can keep ahead of the district court. The merits of the petition become very important as well. And so to the extent that both of those issues can be addressed, as robustly as possible by both parties, you position yourself to have a favorable outcome depending on what side of the V you're on. I'll just breeze through a couple of additional issues relating to PTAB litigation. If you could turn to the next slide. The first, there have been a couple notable decisions this year regarding the rule that decisions of the board to deny or grant institution of IPR, other post-grant review procedures under the American Invents Act are generally not appealable. We've noted two examples here. One involved the timeliness of the petition and that issue being appealed, and the Supreme Court said in Thrive, no, we're not going to review whether it was timely filed because that is part and parcel of the institution decision. And the other was the Federal Circuit's decision in ESIP, which extended that rule to the particular circumstance of whether or not all real parties in interest were named in the petition. So generally, the rule still is you cannot appeal an institution decision. And finally, if you turn to the next slide, I'll touch on this very briefly. There's an emerging issue that we expect may be taken up by the Supreme Court this next term, and it involves the constitutionality of the appointment of PTAB judges. Two decisions, Arthrex and Polaris, have resulted in a combined petition for a writ of certiorari to the Supreme Court that puts this issue front and center. And the issue really revolves around whether or not administrative patent judges are principal officers or inferior officers. And given that there are restrictions on their removal under the AIA, the Patent Act, the Federal Circuit did conclude in Arthrex that they were not constitutionally appointed because they in fact are officers, but they're not appointed by the president. They're appointed by the Secretary of Commerce, and they're not confirmed by the Senate. So whether or not it has much of a practical impact remains to be decided, because it said we're going to cure this by severing this constitutional infirmity and remanding it back to another panel to decide. So ultimately, it may not make much of a difference, but it is an interesting issue that we are keeping close tabs on. And with that, I will turn it over to Erica.
Eric. So we just wanted to touch on, I know time is maybe out already or running short, but we just wanted to touch on a few emerging issues. So we'll start with just enforcement and defense issues in the wake of the pandemic. Obviously, online shopping was pretty key going into the pandemic, but now it's more important than ever, and more stores are going online. So of course, when you have your IP online, it creates fertile ground for infringers to knock off your products, put up counterfeits. We've seen with respect to 3M, 3M is the owner of the N95 mask. They have gone after certain defendants for price gouging. They've gone after defendants for false advertising when they say that they are selling an official N95 mask when they in fact aren't. We're seeing sort of outrageous markups all over the place. We saw it a lot with paper towel and toilet paper products at the start of the pandemic. That's calmed down a little bit, but there's still a lot of, price gouging markups happening. So it's just important to be vigilant about protecting your IP online. And if you want to go to the next slide, there are, lots of ways that you can protect your IP short of filing a lawsuit. Many sites such as Amazon and YouTube have takedown provisions where you can request that they take down content from a seller, or in the case of YouTube, a video, if it's infringing your rights. So you can always look to those procedures as a mechanism short of filing a lawsuit. This is also a really good time to just do an internal brand audit. Take a look at what marks you're using in the trademark space. If you are using things that aren't registered, think about registering them, even though you obviously get common law protection as well for trademarks. And also take a look at what you actually have registered. So often a client thinks they're protected, but it turns out that what they're using in the marketplace is a little bit different than what they registered with the trademark office. So take a look, and if you need to freshen any of that up, now is a good time to do that. As many of you may know, the USPTO has always worked remotely, so they are in a very good position to continue working during the pandemic. They're completely open on the patent side and the trademark side. And you know, they're pushing things through at a pretty steady clip. Now, also when it comes to copyright and trademark, specifically with trademark, you need protection in a specific territorial area. So for example, if you're using your brands in the US, make sure you're protected here. But if because of COVID or just your general business expansion, you now find that you're using your brands elsewhere in Europe or Canada, you actually have to apply for protection in all of those specific countries. You know, it's not one size fits all. So this is a good time to take a look at your portfolio in that sense. And specifically with patents, you should always be mindful of protecting your company's inventions. But now would be a great time to look at monetizing your portfolio if you do already have patent rights available to you. This could be a good time to try to license some of your patents or sell off some of your patents that you're not ultimately using. We actually have a webinar coming up in a couple of weeks specifically on monetizing your patent portfolio. So if you're interested in finding out more about that, please feel free to sign up for that. So next slide, please. One thing that's been coming up a lot lately, which some of you may be familiar with, is rebranding issues. Some companies are finding that their marks that they've used for years in the current climate are deemed culturally or socially insensitive. We've got the Redskins, obviously, that are moving toward changing their team name. The Cleveland Indians, Aunt Jemima, Uncle Ben's, Mrs. Butterworth. The group Lady Antebellum changed its name to Lady A. So this is going on all over the place. And as you can imagine, there are a whole host of issues when you decide to rebrand, especially when you're dealing with a famous and well-known mark. You obviously want to make sure that you select a name that is not already taken by somebody else, but you want to reassure your core client, or your core consumer base that it's still the same great product you were always selling, but you want to get away from those cultural issues. So it can be quite thorny in rebranding, and also making sure that you don't completely abandon your prior marks, because you don't want any ne'er-do-wells coming in and swooping up your old mark and using them in a way that your company would not like or appreciate. So we're closely following this issue. Very hot topic right now on who needs to rebrand and how they do it. And I believe that was our last slide, if I'm not mistaken. Yes. So thank you so much for sticking with us all the way until the end. We really appreciate you joining us today. If you have any other IP questions, of course, feel free to reach out to me or Eric or anybody in our IP group. We'd love to hear from you. And with that, I will throw it back to Jean Paul to close us out.
Great. Thank you, Erica and Eric. I want to thank all of our presenters for today, and especially thank everyone who signed on to attend. Doing this remotely made a lot of work for people that you didn't get to see, who did a lot of hard work behind the scenes. I really need to thank them for making this all happen. Jessica Heck, who kind of headed the thing up and bugged all of us to get our work done. Aubrey Hecker, Susan Seelnock, Abby Toman, Drew Smith, and I probably forgot other people. But thank you all for helping pull this off. Hopefully we'll be gathering in person soon, but until then, we enjoyed connecting with you with this event and hope you found the day and the rest of the series valuable. Thanks again from all of us here at Lathrop GPM. We wish you well. Enjoy the rest of your afternoon.